Nancy was a wife, mother of two, a U.S. nuclear intelligence expert for the CIA. She went in for routine lower back surgery. Quite frankly, in cutting through Nancy, they cut an artery in her stomach, and she had hypoxia, losing oxygen for nearly 23 minutes. They were able to bring her back to life. She now has severe and permanent disabilities. Those severe and permanent disabilities require around-the-clock care and medical attention. The jury found, and it was uncontested, that the economic damages, that is the cost of her medical treatment alone, was $9.3 million. The 2.2 cap in effect at the time wouldn't even cover 1/4 of that. So this just modifies the cap, and you'll see in those handouts right now, modifies those caps in those rare instances when there is a Nancy, and this is why I call this Nancy's bill. Because the way the cap is in those rare occasions, Nancy's care now becomes the family obligation. Husband had to leave his job, care for her around the clock, has no compensation, cannot pay for the medical bills. Patients like these go on Medicare or Medicaid, that's us paying for it. Plus, on top of that, you're talking about less than 100% compensation to the medical doctors and the hospitals who provide the curative care for someone like Nancy. I'm reminded of one of my favorite Supreme Court justices of the United States who said, "To protect against injustice is the foundation of all of our American democracy."
Which one was that?
Thurgood Marshall. He also said that the measure of a country's greatness is its ability to retain compassion. Ladies and gentlemen, this is a small carve-out of the cap. It does not affect the cap in most cases. You'll see right there in your packet, which I've given you, here's a breakdown of the last 15 years of medical malpractice cases in the Commonwealth of Virginia. You'll see the top line, which is more heavily weighted, are in the 50,000, 100,000, way below the cap. If you look at the bottom line on that spreadsheet, what you see is instances over 15 years of no more than 3, 4, 5 a year where it's hitting the cap. I can't tell you how many of those were Nancy cases, but it's very rare when those things actually occur. And quite frankly, we need to make sure that when the Nancy type case occurs, that Nancy is protected, her family is protected, and quite frankly, the medical community is protected. The medical community says to you, and I know you've been lobbied, that this creates an unnecessary stress or burden. But what they're doing by proxy is asking you to protect a multi-billion malpractice insurance agency. You can see what the profits are in billions of dollars in profits that these insurance companies are making on these doctors. Studies have demonstrated that eliminating the cap or even putting on a cap does not lower premiums. The premiums still go up. Eliminating the cap doesn't change it either. In the last 15 years, ladies and gentlemen, the insurance industry earned $3.4 billion from these premiums with a profit of over 1.7. Quite frankly, I do not do medical malpractice, but I do know people who do. But it is rare whenever a settlement is offered where you're at the cap or greater, because to them, they know their limitation is no more than the cap, forcing many of these cases to trial. That puts a stress on the court system as well. And it is also a fact that more than 50% of all doctors are now employed by multi-billion-dollar health systems. In fact, one of the health systems here in the Commonwealth of Virginia, a not-for-profit, owns a medical malpractice insurance company, self-funds it, takes care of that. And the delivery of medical care, we must admit, is different than when the cap was first put in place. You also hear the argument that if you raise the cap, or if you modify the cap in this safety valve, the sky will fall in. The cap will cause their premiums to skyrocket. And quite frankly, I would think competition in a free market is going to prevent that from happening. We've seen where there is a safety valve, such as Maryland and other places that have this exact language, that the premiums have not changed dramatically. Let's not forget either, for those that may not be an attorney in this case, that it is not so easy to file a medical malpractice case in the Commonwealth of Virginia. Quite frankly, it's very difficult. Before a lawsuit, you have to have a doctor put their license on the line and certify that a malpractice was committed. Without that certification, an attorney cannot file a complaint on their client's behalf. During the lawsuit, there are evidentiary rules which require a victim's evidence to be reliable and not based on, believe it or not, junk science. Quite frankly, the cap where medical malpractice insurance claims could be obligated to pay on the claims. We've seen in that spreadsheet that I've just given you that the cap has taken care of those claims, most of those claims that are below that limit. Public data, which you're in possession of right now, shows that in the past 15 years, there have only been 2,728 claims, and almost 90% were less than $1 million paid out. On average, there were only 4.4 claims per year in the $2 million cap range. This is not a case of trying to injure doctors or insult them during a pandemic. Quite frankly, it's just the opposite. This is not about the doctors, the great doctors who we have in the Commonwealth of Virginia, because most of them do such a great job, even though they pay the premium. This will never affect them. This is about actually equity and fairness. We see in medical malpractice claims, quite frankly, that those in minority communities and those that live at or below the poverty level who have these procedures done and malpractice committed against them are unfairly treated, and the cap is a part of that. This is about the insurance companies. Look at the profits that they're making. Quite frankly, profits that go into an insurance company's pocket rather than into the hospital's pocket or the therapist's pocket or the doctor's pocket who's taking care of Nancy right now. Who pays that? You know who pays it? It's us. What we're trying to make sure is, I think the Nancy cases are rare, but we can address them. We can't fix Nancy's problem, but we can use Nancy as an example. We can use Nancy to make sure that there are no more Nancys out there. Because what happened to her is utter tragedy. And we sat here in the General Assembly and arbitrarily decided what the limitations of her damages would be. You will hear now witnesses from the jury who were shocked by what they had awarded her was reduced to the cap limit. And that's the bill, Mr. Chairman. I thank you.
Senator Stanley,
Mr. Chairman.
with all due respect, I'm going to send this to Civil Law Sub. I had no idea it was going to take so long. We have a lot of people that would like to speak on the bill. We have a limited time this morning. So the Civil Law Sub is meeting at 4 o'clock this afternoon.
Yep, Mr. Chair,
Senator Peterson.
we will be having a Civil Law Subcommittee this afternoon at 4 o'clock. We have this bill, we have the bill on subcontractors, so we've got a really good docket, and we look forward to hearing from the witnesses this afternoon.
Mr. Chairman, if I may.
First of all, let me apologize to the people who were coming. I had no idea we were going to have this large a group. My understanding, and I misunderstood, I guess, that this would be put off at some other time. Yeah, Senator Morsi? Is that
Mr.
right?
Chairman,
Yes, see Kristen.
my apologies. Finance did ask for this bill, and today was our last meeting to get bills to finance.
Send it up there. Mr. Chairman, I've got a court appointment at 4 perhaps, I don't know yet, that I've got to go over and take care of, so 4 p.m. is not going to work for me. So if you want to send it to finance, we can do it there. Just report and re-refer.
That's not really going to work. The
Mr.
trouble,
Chair.
how many people, there are a lot of people want to speak, and we don't really have time. How many people want to speak on the bill? We could be here all morning.
Mr. Chair, we have 11 speakers signed up.
I'll tell you what, we got other, let's put this off to the end and decide what to do. If we have time, the trouble is time. And it sounds like you're going to go on and on and on. This sounds like a good hour, right? And we don't have an hour.
Mr. Chairman, I'm done talking, but I remember 23, 30 speakers in the queue on other bills, and we gave them the right to speak.
All right, well, we don't have the time. I'm going to, all right, since this has, the finance needs to look at it too. All right, it'll go, we'll do this. We're going to send it to the subcommittee at 4 o'clock and then see what happens after that. Okay? Subcommittee at 4 o'clock, Senator Peterson subcommittee. All right, without objection, and I apologize for the people out there. I had no idea we were going to have that many number of people. Yes, Senator
McDougall. Mr. Chairman, I'm not going to be voting in favor of this in its substitute or current form, but I do have a concern about process. Are you planning on calling a meeting later today so that it would be able, of courts, after that subcommittee, so this would be able to move on if, regardless of what their recommendation is, because I'm assuming we've not changed our subcommittee process to be a final decision-making arbiter on bills.
If it's coming out of the subcommittee, it has to go to finance. We'll have to do something later this afternoon.
Because, Mr. Chairman, if we don't have another courts committee meeting today,
Right.
then the action of sending it to finance would effectively kill it.
Well, let's send it to the subcommittee at 4 o'clock, and then, can we have a meeting 6 this afternoon? Okay, yes, let's do, well, tell you what, we'll go to subcommittee, then meet at my desk tomorrow morning, and if we have to, if it passes, it could go to finance then.
Mr. Chairman, will the witnesses be allowed to testify in this now new subcommittee?
For the subcommittee.
Mr. Chairman, point of order. Being that I may have an obligation, at least currently, I would ask the subcommittee chairman, understanding what my argument has already been and articulated here before that committee, could that be accepted? And then you get to listen to the witnesses, sir.
Mr. Chair.
Yes, Senator
I think
Peterson.
it's fair to say, other than perhaps Senator Servell and Senator Stanley himself, I am well aware of these issues, and his viewpoint is well articulated, and it will not be forgotten.
Mr. Chairman,
Thank you, Mr. Chairman.
Serville,
Yes, Senator Sherrill.
thank you. And I'm a strong proponent of this bill, and I'd be happy to advocate not only for it, but also for Nancy, who Senator Stanley mentioned, who is my constituent.
Okay.
And so I'll be there for him.
Again, I apologize to all the people out there. I had no idea it was going to take this long. Okay? All right, so with that, we will send it to the subcommittee at 4 o'clock. If it comes out of subcommittee, we can meet at my desk. We'll meet at my desk tomorrow morning.
Thank you, I think, Mr. Chairman.
Thank you, Senator Stanley. Okay.